Good afternoon, and welcome back to KW Property Management and Consulting's Community Association Best Practices Monthly Webinar. I'm your host, Tim O'Keefe, an Executive Director and Partner with KW Property Management and Consulting. We may be having a little technical difficulty today, so just hang in there. If you don't see our faces, you can still hear our voices. Last month, we addressed the impact of Hurricane Ian on the west coast of Florida. We're all still helping our heaviest hit customers in their recovery process. If one hurricane wasn't enough, early last week, we went into hurricane prep mode again as Hurricane Nicole rolled through Florida near Vero Beach before turning north and heading into Georgia. Fortunately, Nicole did not have the same impact as the devastation brought by Ian. But today we're going to be talking about something else. Today we're moving on to a more budget-related and financial planning issue for associations. We will address how properties fund reserves, and we will tackle the impact that Senate Bill 4D will have on the reserve planning for the next several years. So let's get started by introducing our panelists today. And we've got some excellent panelists. First, we have Jeffrey Rembaum. Jeffrey is a firm member at Kaye Bender Rembaum, a Florida law firm that specializes in the practice of association law and real estate. Jeffrey is a prominent attorney on land use matters such as site acquisition, land entitlements, commercial and residential leasing, real estate closings, zoning, code enforcement, and division of condominium arbitration, and a whole bunch of other good stuff. As many of you may know Jeffrey or his name through his Rembaum's Association Roundup newsletter that he publishes. Welcome, Jeffrey.
Thank you. Nice to be here.
Thanks. And then also today, we've got another familiar voice, Roxana Dorigo. Roxana is an executive director and partner with KW Property Management and Consulting. Roxana manages the KWPMC accounting services. She's become a familiar face on my monthly webinars. Welcome back, Roxana.
Thank you, Tim, and thank you for inviting me back.
Thanks for accepting the invitation. I can always invite you. That's the easy part. I never know if you're available. So we do have some poll questions that hopefully y'all can see. Please respond to those during the webinar if you'd like, and then I'll share the results, and that'll help kind of craft for our panelists who is on the call and the type of challenges that y'all are faced with. So let's get started with you, Jeffrey. We all know that funding for reserves has always been a debated topic within boards. The often asked question has been, do we fund for reserves? Do we special assess when funds are needed for projects or building repairs? Or do we take a hybrid approach and partially waive reserves and fund less than 100%? It seems like the Florida legislature is taking away a condo board's flexibility to fund reserves. So without getting into dinner time, can you give us kind of an overview, Jeffrey, of what exactly Senate Bill 4D addresses, what it doesn't address, and then we'll start with that as kind of an open-ended question. We'll move on from there.
Sounds good. And thank you for the shout out about Rembaum's Association Roundup. Believe it or not, we have a distribution list of around 15,000 board members and managers. So if there are participants on this call and they're not receiving it, and they're very short articles, all dealing with new court cases, legislation, how things are being interpreted, things that board members and managers need to know. And I'd also point out that myself and about half of our attorneys over here are board certified experts in the field of community association law. And this is what we do day in and day out. Turning attention to Senate Bill 4D. By the way, Tim, this is a living prophecy that you and I, of course, not Roxana, but you and I anyway have a face for radio apparently, since the cameras are not able to turn on. It's an old.
Well, based on your picture, you look like a very handsome man, Jeffrey. And I know
it's an old picture. Let me tell you, it's an old.
For me, I'm happy to sit behind this and just have my voice be heard.
There you go. There you go. So
when your mother tells you you've got a face for radio, you know you must be bad.
There you go. Senate Bill 4D. So really, we have three new terms that are introduced that everybody needs to be familiar with, which are the milestone inspection, and we'll talk about phase 1 and phase 2, substantial structural deterioration, and also your favorite, the structural integrity reserve study. So these terms are brand new and are relevant legislation. We need to talk about what the deadlines are for both parts of that legislation. We need to talk about the phase 1 and the phase 2 of the milestone inspection. We need to talk about, I don't think we're going to get into today, the post milestone inspection. Hey, I see you, Tim.
Yeah, it
Hi
works
there.
now.
Let's see. I'm going to try it. Oh, had it, lost it. And there I am. Hello,
There you
everybody.
are. Okay.
It's nice to be seen and nice to see you. All right, Roxanne, just so you know, your microphone is muted. It may be on purpose. I don't know. So I'm not going to go into the post-milestone inspection requirements unless we actually get there today. But other issues are who pays for them, failure to obtain them, the manager's duty, what is the fiduciary duty of the board of directors. We have in the Sears Structural Integrity Reserve Study a whole new category of reserves, funding requirements, no ability to waive or reduce reserves after December 31st, 2024. If you have no takeaway from today, that's a takeaway you want to remember. No ability to waive or reduce after December 31st, 2024. And we can talk later about how that is going to play out in the long term. We can also later talk about the glitches that are in this legislation and time permitting. But that aside, let's talk about the milestone inspection and the two parts of it, right? We have two terms within the milestone, the structural inspection itself. The milestone inspection is dealing with a structural inspection, including load-bearing walls and primary structural members and systems, and it has to be performed by a Florida licensed engineer or architect. Now, this expert has to attest to the life safety and adequacy of the structural components and determine the general structural condition of the building as it affects safety. And whether or not he also has to make a determination, or she, if there's any necessary maintenance, repair, replacement of any structural component. Now, this is something that I haven't heard a lot of people talk about, because even though you're going to have the requirements of the Sears, the Structural Integrity Reserve Study, if the engineer doing the milestone sees something that gives him concern, he may put out in his report, this needs to be fixed, and that's going to lead to an immediate assessment in addition to the Sears, but it will, at least when you fix that component, it should have a positive impact on your reserves, because you'll be able to then take that repair into account. Now, what does substantial structural deterioration actually mean? And basically, it is substantial structural distress that negatively affects the building's general structural condition and integrity. So all of those terms are in the legislation. If you want more detail on it, if you go to my firm's website, kbrlegal.com, to make it easier on you, go to rembaumlaw.com, and there's a repository of all the articles, and you will see in there the articles that we've already published that go into a tremendous amount of detail on the milestone. Now, the milestone, you've got a few dates you really need to be familiar with. The short story is the milestone generally is 30 years from the date that the building receives, the condo or cooperative, receives its 30 years from the date that it received its CO. If you're within 3 miles of a coastline, and we can talk about how to interpret the term coastline another time, but if you're within 3 miles of it, then you're looking at 25 years. And if your building the CO was issued before December 31st, 1992, then your deadline, all right, means your building is already 30 years old. So that brings us to the deadline of December 31st, 2024, in which your milestone report must be completed. Now, when you hear that the Sears Structural Integrity Reserve Study also has that same date of December 31st, 2024, you should start thinking about economy of scale and using the same licensed architect or engineer to do the milestone as would complete the Structural Integrity Reserve Study, at least those portions of the Sears that require the engineer or architect, so you don't have to pay twice to 2 different companies. Remember, you have the phase 1 and phase 2. That's completely up to the engineer on the milestone. He does his first visual inspection. If he thinks that he needs destructive testing, more non-destructive testing, et cetera, and so forth, to make sure that the building's structural load is safe for the intended use, well, then they will have the ability to say, hey, we need to do this phase 2 report. So if your building is older and you suspect you have some issues, you might want to think about setting aside some monies, and we can talk more about that, and we can talk about loans, et cetera, and how to fund some of these other items. Remember that after the milestone is completed, a copy needs to be provided to every owner. It needs to be posted in a conspicuous place on the association property. And if you have a website, then you need to put it on the website as well. All right.
Jeffrey, let me stop you right there just for a
Uh-oh.
second. Quick question coming in from Kevin. He says, are milestone inspections applicable to HOAs?
Not at the moment. The relevant legislation is referencing chapters, condominiums and cooperatives. However, there is an exception within them, right? We always talk about above, if you're 3 stories or more, if you're above 3 stories rather, but there's an exception for clarity. The milestone does not apply to a single family, 2 family, or 3 family dwelling with 3 or fewer habitable stories above ground. So the little bit of confusion between that, I know there's one listener in particular who doesn't think that's a glitch. I still think that could use some additional clarification on that point. Barry, if you're listening, that's your shout out. All right, so, yep.
Yeah,
No,
just
quick-
a question actually from, when the bill passed, the codification actually is outside of the 718 and 719, right? Isn't it in the 5 series and the building?
Yep, it's in the building inspection areas, and if you want the actual number, I can give it to you for you buffs out there that like to look at the law. You could pull up Senate Bill 4D in its entirety. And it's so funny, I just had the relevant statutory number in front of me, and when it pops back up again, I will let you know the exact place in the 2022 legislation where you can go and find that. Rather frustrating when I just had it in front of me. Here it is, section 553, chapter 553, section 899. You will be able to find the actual language set out in the law for the milestone. Once again, that's 553.899. So I hope that helps a little bit. Should we jump over to the Sears for a few moments and do a brief introduction on that?
Sure.
All right, so the Structural Integrity Reserve Study. What do we know for sure about the study? We know that it has to be completed by December 31st, 2024. If you've been a good association and you've been reserving all along, even if not fully funded but partially funded, the impact is certainly going to be a lot less on your association. But now the required reserve, the sacrosanct 3 that we had in the past, that's how I used to refer to them all the time, painting, pavement, roof, that has now been expanded to roof, load-bearing walls, and other primary structural members, floor, foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and the same catch-all, any other item with deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace or maintain affects those items that we just went through. So obviously it's going to do so.
So
Now,
basically they did like 2 categories, right? Now they definitely define what structural components are and what's other.
well, they don't really tell us what's other, but they certainly do define the structural components. And what's interesting is the Sears can be really performed by anybody, except that the visual inspection of the Structural Integrity Reserve Study must be performed by an engineer that's licensed or an architect that is licensed within the state of Florida to do so. So that's just something else to consider. Remember, no way that this report has to be completed. Doesn't say it has to be in effect by, since it has to be completed by December 31st, 2024. And we know that you cannot waive or reduce reserves after December 31st, 2024. So we can play around a little bit and talk about, if you like, some hypotheticals where an association, has a budget in October and passes and receives their Sears maybe later that year. And then when will their Sears reserves go into effect? So let's be sure to come back and revisit that before the end of the webinar. Now, if you don't get your Sears, board members, that is a breach of your fiduciary obligations to the association, which means it is actionable against the board member. It's a breach of fiduciary duty. That could be one of the few torts where that there could be possibly some individual liability. You don't want to get caught up in that. So just make sure you never leave your flanks exposed, as they say. So make sure you have this the Sears completed in a timely fashion.
And just to be clear, when Jeffrey's saying Sears, he's talking about Structural Integrity Reserve Study, not Sears and Roebuck. Okay, so we are talking about the reserve study.
Oh, it's bad. You're assuming our listeners may even know Sears and Roebuck. I know
I
Sears.
would have to believe that a majority of our listeners know Sears and Roebuck. They probably even know what a Sears house is. So, they're
Yeah, right. Order it
homes
out of
that
the
Sears
catalog.
used to sell. And I had an uncle that used to sell for Sears. So I know, I don't know it, but I heard about these houses. So
Mhm.
anyway,
Okay.
we're talking about structural integrity reserve studies, which is phase 2 of the bill as opposed to phase 1, which is the milestone studies.
Hey, can we take a second and talk about fully funding and what fully funding means? I see so much confusion out there.
Yes.
Yeah.
And
Well,
I-
and Roxana's life deals with that and educating people on what that means because
And now it's even more, right? It's many more questions about what is fully funded. Yeah.
Well, I could give you what I think, how I interpret it, but I don't want to step on your shoes
Let-
either. And you're here, so if you want to.
No, go ahead.
let me clean up one other issue because
Sure.
I have Betty from St. Pete and now Stanley's asking basically a similar question, which is looking for a distinction between 3 stories and above and less than 3 stories. So what does that actually mean? When it says 3 stories and above, does it mean if you're 3
Well,
stories, then
talking
you're
about
included? Or is it 2, if you're less than 3 stories, you're not included?
Great questions and needs further clarity from the legislature. I think if if I were dealing with a specific situation, we're going to have a different result, I think, for the milestones than the Sears, and we have to actually go into the exemptions. But remember, the exemption we just discussed a few minutes ago referred to single family 1, 2, 3-story homes that were not subject to it. So if you're not the single family home, then if you're 3 stories, there could be an implication. So because there's just a little bit of gray in answering that question, I want the listeners to reach out to their own association's lawyers to get that particular interpretation. So there is I don't want to create any confusion in the marketplace through this webinar on that particular issue. I consider that issue to be a little bit of a glitch and still needs further clarification from the legislature.
Okay, so Betty and Stanley, what we're saying is that it is not clear what 3 stories and above means just yet. So hopefully we'll get clarity in the next go round of legislation.
Right. So the milestone, because the question is good. It applies to a condo or cooperative building, 3 stories or higher, but not to a single family, 2-family, or 3-family dwelling with 3 or fewer habitable stories. So let's do it again. Applies to condo and cooperative buildings, 3 stories or higher. We're going to start with that. 3 stories or higher. But if you are a single family, 2-family, or 3-family dwelling with 3 or fewer stories, then you're exempted back out of the milestone. So some people think that that's not a glitch at all. And if you read it, and I kind of see that point as well, but it does there is confusion in the constituency. So I think the legislature owes it to the state of Florida to straighten that out. So it applies to buildings 3 stories or more, but ask yourself this to get the clarity. Are you a single family, 2-family, or 3-family dwelling? And if you're not, doesn't matter, right? You're 3 stories or more, you're doing it. But if you are a single family, 2-family, or 3-family dwelling, and you have 3 or fewer stories, then you don't have to do it. So there's a little more of a complete answer, but I'm still going to direct you back to your association's lawyer to get that answer in writing. So, and the reason why is, God forbid you go the wrong direction based on legal advice, you get to hide behind advice of counsel.
And so let's clean up one other thing, Jeff. David said that you've mentioned a few times on this webinar already that funding starts after 12/31/24. He had heard on another webinar that it doesn't start until 2026. So can you?
Okay. I guess we're going to get ahead of ourselves. No, what I said, and whoever wrote that is not an accurate representation of what I said at all. I said your Sears Structural Integrity Reserve Study must be completed by December 31st. 2024. I did not go into when you have to start funding. So imagine this hypothetical. Let's say you're the condo association and you've contracted for your Sears Structural Integrity Reserve Study, and you've adopted your budget in October for 2025. You then get your Sears report from your engineer, let's say in early December. So now you're in line with the statute. You received it prior to December 31st, 2024, but your budget is already in effect for 2025. So you're using the old regime of the old reserve regime for that year, and you're not actually going to be implementing the structural integrity reserve study until the next year's budget, right? Which would in effect be 2026. But don't forget, even though you may play the date game in that regard, December 31st, 2024, even if you're using the old reserves, you still can't waive or reduce. So that part is patently clear. Hope that made sense to everybody. And be aware, remember, the legislature is going to be looking at all these things. They may consider that to be a glitch once they figure out what they've done, and they may come back and rein that back in. It's hard to say.
Okay, so thank you for that clarification. Let me go back to Roxana now and talk about what does fully funding mean. We'll get the CPA's version, and then we can see what the attorney has to say about that.
Absolutely. So there
We
is
got all the
confusion.
professionals.
Yeah, there is confusion. When someone looks at their reserve study and all these components listed, and there's a big dollar amount at the end of, let's just call it 14, maybe $22 million, they're like, we have to be fully funded. It's like, well, there's a play on words, or there's an understanding that's missed here, is that for a budget to be presented with fully funded reserves, it has to be a calculation out of one or two methods: straight line method or the pooling method. So the straight line method is a simple formula. If you have a roof and the roof is going to cost you, very simply, $120,000 in 10 years. So you need to put away 1/10 of that amount. I think that's $12,000 every year for the next 10 years. And in order to have that money ready for the roof replacement. So that $12,000 actually is fully funded calculation that you could put into your budget. And now we have a budget presenting fully funded reserves. On the opposite end, the pooling method is based on a projection of expenditures over the longest remaining useful life of any one component. Let's just say, for simplicity's sake, for 30 years plus. And you just have to have enough money to be able to pay for the expenditures projected for any singular year. And there cannot be a balloon reserve contribution in any one given year. So you need to have sort of a median number that is to fund your reserves over that 30 years. You can build in some inflation into the costs, and that's all done through the reserve study. And that calculation produces an amount called the reserve contribution for a particular year, and that's inserted into the budget. And now you presented a budget with fully funded reserves. So I think there's a misconception as to being fully funded versus the calculation of one of those two methods. And Jeffrey, I don't know if you think the same, or is there a different thought?
Generally the same. I'll say the confusion comes in a lot because we don't have a definition in the legislation, and other states use that term, and that's really where a lot of the confusion comes in, quite differently than we do in Florida. So I like to use $100,000 as the example because I am not a CPA, though I am married to one by disclosure, but I can do the math on $100,000. It's very simple, 10 years. And if we're fully funding and it's $100,000, so we're putting $10,000 a year into the reserves. To fast forward, let's say we waived every year and we're in year 7 of the component and it's a $100,000 item. To fully fund for that year, we're actually going to have to fund it 1/3 of the $100,000, $33,333 or so and some change, in order to be fully funded for that year. I fully agree with pooling as well. It works the same way, and it just assumes in the pooling method that you will have the requisite sum of money when any of the components go, taking into account the life of all of those components that are in the pool. The questions interestingly come up about, well, Jeff, we've been pooling these 3 items. Let's say we've been pooling painting and roof and pavement. Well, what about these new items? Can we pool those too? Is that a new pool? Is that the same pool? Do we have to go straight line? Once again, we don't have good guidance in the legislation. So it would be nice. Most of the practitioners I'm talking with seem to be comfortable, and I think I'm comfortable with this too, subject again to what the Division of Condominium may come out with or legislation. But I think if you start out pooling in the structural integrity reserve study, that's going to be okay. But if in year one you go straight line and you want to make any changes on the pool, then I think you're going to need that membership vote. So
Right.
bear that in mind in year one of your structural integrity reserve study. How do you want this to flow? And your reserve specialist hopefully is giving you both, the comparison between pooling and straight line. You may have
So
to
you
pay a couple
think-
dollars extra, but
You think there'll be two pooled reserve amounts, so maybe structural and then other?
well, yes, and unless you actually started the pool with even more items in it. So you had all the items in what we call little g, and those were all the enumerated items I read that are subject to now being in the structural integrity reserve study. And if you wanted to put other items in as well, in year one, I have to give that some thought, but that might be okay too. Always better to get the vote of the owners, because then you're beyond reproach anyway. And if you let the owners know, hey, we can't waive, we can't reduce, but we can at least lower the bill by pooling, I have a feeling the members are going to go for that anyway. And then that way, if you have that one cantankerous owner, and I know every building and every association has them, they only hurt themselves in the end because they raise their own assessments. But if they make a complaint and it leads to some sort of investigatory action, at least you'll have the vote of the membership to show the division and do away with the case. So that's something to think about as well.
So another question, I think we've addressed it now. Darlene was asking about, will pooled reserves be allowed for 2025? And the answer would be yes, unless legislature does something differently this next go around, and next legislation for the next few years.
Except that I have to give deference to the other association lawyers there, because this is a very gray area in the law as it exists. So you need to get that advice in writing from your association's lawyer if you're going to go to the pool. If you're going to go to the straight line method, you don't need it. But if you're going to go to the pooling method, you need to touch base with the association's lawyer, because, get two lawyers and get three opinions kind of a thing.
Yeah, and just an interesting point that I hear from our partner, Sandy Bennett, we have a consulting arm where we do help developers build their beginning budgets. And the attorneys, that work with those developers have asked them to do the reserves on a straight line method.
Now, what's interesting is if that will change, because in the past, condominium developers had the statutory right to waive reserves for the first 2 years. Now, when does the year begin? Immediately upon the recording of the declaration of condominium. That takes thin air and converts the units, and we have common elements even if we haven't built the building yet. So now that developers are going to have that obligation to fund, which is only going to pass through to the owners anyway, but will they go to the pooling method so that they can at least make that a little bit lower? And what do you think, by the way? If you had to take a percentage guess, just a wild guess, if you go from straight lining to pooling, what the average percentage is in the reduction of the total fully funding for that year, if you were to compare straight line versus pooling? Have you noticed a number-ish kind of?
Yeah, it's definitely lower. And
Yeah.
I would say somewhere between 25 to 30% lower.
So a significant amount of money.
It is.
Yeah,
It truly
especially with
is.
these folks that haven't reserved at all before, and all of a sudden, so now at least they can find a way to at least lower those reserves by at least 20 to 30%.
Yeah.
And even more importantly, it gives you access to the money too, in case that a project gets bigger than what you thought it was going to be. So you have access to the money. I want to give some poll results, because I think we probably have most of the answers that have come in, just so Roxana and Jeff, you guys get an idea who is listening today. So one of the questions we asked was, how old's your building? 1 to 10 years, 6% of our listeners, 11 to 25 years, or 18% of our listeners, 25 to 40 years. So now we're starting to talk about, milestone and structural engineering studies required 28%. 48% of our listeners are in buildings 40 years or older. So this is a very pertinent topic that we're talking to with this group, okay? And then, have you had a reserve study completed in the past 2 years? 52% said yes, 45% said no, 3% doesn't apply, must be HOAs. So let me stop right there and just say, and ask the question to both Jeff and Roxana, which is knowing that 48% of our listeners have not had a study done. And even if you had in the last 2 years, what's that mean for the real cost? Because what we've seen as repair costs are very different today than they were 2, 3, 5 years ago when you might have had the last reserve study done. So how good is that reserve study if it hasn't been done in the last, I'll just say post-pandemic?
Yeah, even last year, we have 2 examples that I've been involved with. They have a reserve study from last year, and the reserve study in this year increased their reserves by $1 million. And it's because of a couple of costs: external painting, and it has to do also their location. They are on the water and they're in a predominantly developing area. So the developers are in town, in that particular area of town, and the costs are just through the roof. I mean, even a year made a big difference to their reserve study.
Let's talk. I'm going to answer the question a little differently than directly, because I just was contacted by a national commercial management company, really international. They are one of the big ones. And we were talking about the 48%, those buildings older than 40 years old, and what is going to be the mechanism for them when they can't afford this. And really what they were looking for is it's going to be a development boom, I think, in South Florida, because what's going to happen when they can't afford the reserves? One option will be, if the membership gets together and they can value the units, they can make a package deal to a potential developer, terminate the condominium, and they can build something new in that spot. Some associations, when they look at these numbers, may be in a position, it would be unusual to have a redo and a knockdown and a rebuild on theirs. But again, it creates a termination of condominium and you have to create a new one, which is really interesting. So I think we're going to see some really interesting twists. I think we're going to see, unfairly, a lot of people who cannot afford this. And it's almost, these laws, this is interesting, could almost be considered an inverse eminent domain claim. In other words, the government isn't directly saying we're taking your property, but the effect of the governmental laws is it's a taking, right? We can't afford this, and it's going to be a real fundamental problem that I do not believe the legislature has thought through all the way when it comes to allowing, especially the older associations that have never properly reserved, and we can talk about why that may have been right or wrong over the years, but still there needs to be some kind of way to ramp this program up. This is going from 0 to 100 miles an hour in 1 second, literally. And that's going to be problematic for everybody.
Well, and the other thing that we haven't even talked about, which is kind of the elephant in the room too, it's not just about these reserve studies and the cost of funding. We all know that insurance is going up crazy. There's 2 major events that have been the drivers for the conversations that we're talking about. One, from an insurance standpoint, it's the result of Hurricane Irma and all the costs associated with that. We haven't even been touched yet by what the $67 billion worth of losses that have been reported on Ian. And that's going to have a profound effect in the coming years. And then also we have the reserve study requirement. So those 2 things I was talking to a property on a barrier island recently that was going from $250,000 to $800,000 for insurance. Plus they have 0 funds for reserves. And so you couple that together and you get to the point where, like, what can we afford to do? We have to be able to do something to keep the building up to legal standards. So because
right.
And I don't know if you look like you go ahead and comment on that, Jeff.
Oh, I was just going to say that it's a shame that the legislature took out the mandatory reserve study requirements that were there years ago, and couple that with there used to be owners had to have insurance. They had to have an HO6 policy, and now they took that requirement out as well. I was surprised they didn't put it back in with all of the Senate Bill 4D issues, but maybe with the insurance debacle as it is in the state, they didn't want to create additional burden on the owners. But if you've ever been through a condominium casualty and where the one owner who didn't have insurance is the one who ends up causing the problem all the way down the stack, it's a real problem. So for you condominiums out there, you might also want to think about amending your declaration to provide that every owner must have an insurance policy on their unit. So at least you have additional coverage should that owner negligently be the cause of some catastrophic failure at the association that costs 10, if not hundreds. I've been down this road where it's run hundreds of thousands of dollars.
Well, and interestingly, we have a client in Orlando that's a condo that's very tough on owners that way. If it's a high rental property and you can't rent unless you have homeowners insurance, and if you don't have homeowners insurance, you have to prove each year they fine you. So you get a fine for that.
Wow.
So
there you go.
That's they're being tough on that issue,
Right.
making sure that owners are complying with the rules, because those rules are written into their condo docs.
I just published an article in the Community Association Journal last month all about the failure for owners to have the HO6 policies. So if anybody's interested in reading more about that, again, you can go to KBR Legal or rembaumlaw.com, either way, and find the repository to the articles there, and that'll be the most recent one.
Okay, and then the two big impacts on budgets are insurance going up. Insurance has been a result of hurricanes, and also the tragedy in Surfside with the property there. And that's what's driven the new law, because when the legislature met last year and got out of session at the end of March, they didn't address the collapse of Champlain Tower South. So the governor brought them back together in May and said, you will do something about it. And they spent about 48 hours and passed this massive law. So hopefully this year, we don't expect significant changes to it, but hopefully they'll clean up some of these issues that we're talking about today.
They use the word common area in Senate Bill SD4. Really? Condominiums don't have common areas. They have common elements. Cooperatives have common areas. So that's just an interesting, pretty big glitch, if you ask me. The list goes on and on and on about the glitches. What is a building story? How do we measure the story? How long do you post a milestone report? It just says you have to post it after you get it. Is that forever? How about Kaufman language? No one has examined this yet. I'm waiting for a lawyer to bring this in to say, because of the economic effects, this is a substantive change. We don't have Kaufman language in our declaration, therefore not applicable to us. I wouldn't be comfortable taking that position, but I'm sure someone is going to try it and we'll eventually get some case law on the issue. Essentially, for the listeners who don't know what I'm talking about, Kaufman language is where an association puts a sentence into its declaration of condominium. Remember that that declaration is a contract between the owners and the association, and it's subject to the laws in effect at the time the contract goes into effect. But if you put a sentence in that document that says, subject to Chapter 718, here comes the Kaufman language as it is amended from time to time. Now, this only applies to substantive laws, not procedural laws. So, Tim, if I offer to sell you a pen for $1, play along with me, will you buy it?
Will you sell it to me for 75 cents?
Done.
I'm being a board member.
Will you buy it?
75 cents.
Fine. Will you buy it?
Sure.
Okay, we go to bed and we have two hypotheticals. We go to bed and we wake up the next morning and it says, there shall be no pen sold to Tim O'Keefe in the state of Florida. Headlines. Can I sell you still? Can I deliver to you that pen? We had a contract before the law went into effect. And the short answer is, yeah, we can, because they struck at the heart of the deal. That was substantive. But what if we went to bed and we woke up the next morning and we find the legislature says, before you can give that pen to Tim O'Keefe who bought it, you got to wait 48 hours. That's more of a procedural hold than it doesn't strike at the heart of the deal. It was a minor inconvenience and delay. So we can call that procedural. My point and where I'm going is Kaufman language affects substantive laws and makes them applicable immediately to those associations that have the Kaufman language. So the question is, what is Senate Bill 4D? Is it procedural or is it substantive? To which I say, I think I can create arguments on both sides of that equation. But it would be nice to have clarification that regardless of Kaufman language, this legislation applies and do away with the question to begin with in the legislation itself.
Okay, so I'm going to finish up our poll questions. I just have a few more just so you all understand Next question was, in the past, has your association fully funded reserves every year? 26% said yes, 69% said no, 5% didn't apply. Okay, so most people waive reserves or partially waive reserves. 69% of our listeners. Are you concerned about the impact funding reserves will have on your future budgets? 89% said yes, 9% said no. That 9% is probably fully funded, I would think. And then, are your reserves funded as pooled or straight line? 51% of our listeners have said pooled, and 31% said straight line. There's 18% that said it doesn't apply. Not sure why it doesn't apply, but again, 51% have said pooled. So I would think pooled would have been a little bit higher overall than what we're talking about. So, because I know a lot of properties have moved to that. So, Roxana, I guess a question for you, since it's budget season for us, is kind of wrapping up and we're getting everything done. Can you give me a percentage of properties that you would say have started to fund reserves in 2023 for the new law that's coming out? Or like what percent of the people are saying it may not be a significant increase from the past, but we are starting to make moves so that our ownership group knows that it's going to start costing more and we're moving in that direction?
Well, that was definitely a push from us, from accounting to the district managers to the managers, and we did a lot of training. We had a whole big session with each manager to say, what are we going to recommend due to this new bill, and what is it? What's the effect to you in 2023? So we did a big push to say, you're going to come up with that fully funded reserve contribution, but we're going to go to your boards and call us in from accounting, and we want to increase that amount. We don't want to just say that's the amount, because there are components, just like Jeffrey said, there's a whole list of components, and 99% of the time, I've never seen foundation, for example. I've never seen windows. I've never seen low-bearing walls in reserve studies. So inevitably, once those are added, there's most likely an increase to that fully funded calculation of reserve contribution. So we've been requesting that they increase it. And luckily, some have, listened. And overall, across all of our associations, there's been a 19% increase in reserve contributions.
Nice. You brought up a really good point in that explanation as well. Remember that reserves are not only for replacement, but also deferred maintenance. So when they're doing the visual inspection portion for the structural integrity reserve study, they don't have to examine the foundation and think, well, gee, how much will it cost to replace? They may be looking at it and see some signs of weakness in the columns and things like that that are part of the support structure, and consider that the deferred maintenance, if you will, that's going to need funding over time. So just need the audience to understand it's not just replacement, like a new roof. It's also deferred maintenance is included in that reserve calculation. And that's where the columns and the foundation comes in. And I think also, as a little heads up to the listeners, when you are engaging your engineer or architect and they're doing these things for you, let them know who's responsible for the windows. The last thing you need is a window calculation when in fact the owners are responsible for the windows. So then do we have to include the windows in the reserve study? Yet another glitch. But I'm going to opt on the side, if the association's owners are responsible for the windows, I think it's a pretty safe bet that there wouldn't need to be a calculation in the reserves for those windows. But there may be common element windows, right? The downstairs lobby.
Right.
Here's a question from Leslie for structural integrity reserve studies. She says, how do they check the floor, foundation, and load-bearing walls?
Well, we should have had an engineer or an architect on this call, because that's going to be up to them based on their visual inspection. And remember too, if they also did the milestone, then they're going to do that phase 1. And if warranted, they're going to do the phase 2, and they're going to get a whole lot better idea of the condition of those items when they do the milestone.
So let's just talk for a second about that, Jeffrey. Who's qualified to do these studies?
Licensed engineers and architects, licensed in the state of Florida.
Because a lot of reserve studies, there's companies out there that are reserve study companies that are accountants, they're not qualified to render an opinion on the condition of foundation, load-bearing wall. Like, they can't really do that, right?
Right, it needs to be some cooperation, I think, between the architect, engineer, and that company that does the rest of the reserve study.
So it seems like most everybody on this call has done reserve studies in the past, not more recent. Make sure that you know who's doing your study, because it may be deemed inappropriate for you or irrelevant if you don't have the right level of person doing that work anymore, because the accounting firms, now they do a fine job, but I don't know that they're as qualified now based on the new laws to be able to render an opinion on the current condition, at least, and future condition of asset like that.
Right.
Okay.
I'm not even sure there's enough engineers and architects in the state to do all this work to begin with in a timely fashion. So what then if there isn't? And I guess we'll only find out in the test of time. I know people who adamantly believe there aren't enough, and a few people who believe there are. So who's telling the truth? I think they both think they are, but what's the answer? I wish the legislature would have given a little more thought before they put these burdens on those architects and engineers, and maybe broaden the pool as to who can do these things.
So I think there's an old song that says something about mamas, don't let your babies grow up to be cowboys, have them become engineers. There's a lot of work in Florida.
I think you'll see a big push of outside state engineering firms coming in and getting licensed to help out with this. Yeah.
Okay, so we got a lot of questions that came in, and we got about 10 or 12 minutes left. So I'll try to hit some of the questions. Most of my pre-work always goes to the wayside. So I'll see what I can, we're going to go back and hit on some of the questions that came in. But let's see, Elizabeth's asking, can you expand on not being able to waive or reduce reserves after 12/31/24?
Sure. You can't waive or reduce reserves after December 31st, 2024. The end. That's it.
But isn't there a distinction? It's for the structural component.
Well, again,
right?
depends who you ask. It's quite possibly so, yes. Once again, we need better clarification in the legislation as to that point.
Let's see.
I'm going to find the exact sentence for us in just a second.
Can
So-
co-ops self-insure according to statutes?
What's that?
Can co-ops self-insure according to statutes?
Honest to God, I'd have to look up chapter 719 and see if they have the same ability to self-insure as do the condominiums. I don't have enough cooperatives in my book of business to know that one off the top of my head.
Okay, I think we answered this, but I'll ask the question for Judith to get clarity. The structural integrity reserve study reports due 12/31/24. However, when must funds be assessed and funded?
Well, depends, right? We did our study. Let's say we got our structural integrity reserve study in September of 2024, and we pass our budget in October of 2024. Well, darn it, those components, those results better be in the 2025 budget
Yeah.
and accounted for. But let's say we did our budget in September, but we didn't get our structural integrity reserve study in time, and we got it in December, still in time for the deadline of December 31st, 2024. The legislation doesn't say we have to take it into account by 2025. It says you have to complete the study by December 31st, 2024. So you passed your budget in September, you got the report in December, meaning you're not going to take into account the structural integrity reserve study until later in 2025 when you're preparing the 2026 budget. And unless the legislation gets changed in a glitch bill or something, that's a plain reading of the legislation. Division may feel differently about it, but time will tell.
So, okay, and then Elizabeth asked this question, can you, when we were talking about pooled and straight line, can you do both? For instance, straight line for a roof paint project, but pooled for structural.
Oh, sure. I mean, you can absolutely have straight line and pooled at the same time. You can have a group of items in pooled and other items in straight line.
Yeah, but that'd be
Okay.
strange. I mean, I don't think there'd be a lot of flexibility there. You know, why have the pool then?
So-
Because, well, like the old days, right? Some associations would just have one or two items in the pool and have other items on straight line. I've seen that plenty.
Okay, and then Lorette is asking about inflation. We talked about how costs are going up for replacement costs, but she's saying, what does the new law say about current costs versus future costs?
I'm going to leave that one to you, Roxana.
Yeah, there really isn't any change in how the methods are being used. What is the number that you use? What is the amount you use? That wasn't really discussed in the new statute. The methods, Jeffrey, I don't see a difference. I think the methods were left alone. They just said straight line continues and pooled rules continue. So there hasn't been any change.
Right. The really only question is, can these items be pooled right off the bat?
Mhm.
That's the bigger question, I think.
Okay, and
Can you
Roxanne,
allocate some of the existing pooled to the structural?
It depends
because-
what's in the existing pool, and you really need to reach out for advice of counsel on that answer. Because it's going to be different for every single association, depending on what's in the pool to begin with.
Roxana Harry's asking, are reserves based on 10% or useful life?
What does she mean 10%?
Yeah, what's the 10%?
I'm not sure what you mean by that, but it's based on the useful life of the component.
Yeah.
Deferred, remember, you're using the reserves are for deferred maintenance, irregular deferred maintenance, if you will, and replacement.
Okay. Let me see. John's asking, will this recording be available later? Yes, it will, John. We put it on our website and on YouTube, and we actually will send it out tomorrow to everybody that signed up. So it will be available. Barry, our friend Barry is asking, why is there an issue regarding waiving non-paragraph G reserves after 12/31/24?
Why is there an issue waiving non-G reserves?
Why is there an issue regarding waiving non-paragraph? I don't know if that's.
The non-structural components.
Correct. I'm going to come back to that answer in just a moment. Let's go to the next question so I can give Barry a good answer.
Okay. Franklin in Key Biscayne wants to know, it seems like the lifespan for building components is being shortened by insurance companies and building departments. This would discourage using premium, longer-lived materials for such things as exterior paint or roofs. Is it feasible to use better materials and get better life assumptions in calculating reserves?
I mean, potentially, right? I mean,
I
for
mean, the reserve
exterior,
study should factor that in, right? The reserve study should factor in the quality of the work and how long something's going to last. So,
yeah, and for exterior, don't they get the warranties? So
mhm.
sometimes it's a 7 or a 10-year warranty, so we can base it on that.
And then Devin in Jacksonville is asking, can a condominium association have both structural integrity reserve study and a traditional reserve study for other maintenance and other items in a condominium building?
Yes. But I think you need to leverage off, you already have your licensed engineer on property. Have them do the whole study, right? For all components.
So the little g items, back to Barry's question, the little g items, and I have to focus on one in particular: roof, load-bearing walls, floor foundation, fireproofing, plumbing, electrical systems, waterproofing, windows. Here's the kicker. Any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000 and the failure to replace or maintain such item negatively affects those items above, for lack of a better way of saying it. So would one of the two of you please tell me a reserve item that is not roof, load-bearing walls, floor foundation, fireproofing, plumbing, electrical systems, waterproofing, and exterior painting, windows? Tell me something else that is going to be reserved that doesn't affect those items. Because if it doesn't, then you can waive or reduce the reserve. So to Barry's point, the items in little g, you can't waive or reduce. Other items you can, but what are the other items? At that point, what are the other items? And there's another glitch as well, because there's an ongoing debate amongst attorneys in regard to whether a condo that's under 3 stories can waive or reduce reserves for any of the reserved items required to be in the Sears report that are included in the under 3-story condominium. In other words, roof and painting and that sort of thing. What's going to happen to their option to waive or reduce? Something else to look at. But give me an example going back to another item that would be in the reserve, right? That I guess maybe the
Furniture, fixtures, lobby renovation,
HVAC system, I think, is another one, right?
yeah, HVAC.
Anything not dealing with structure can probably still be waived or reduced. So what you want to be careful of is not putting those items in the pool to make things a little bit easier. And you might want two pools at that point, right? One that is subject to waiving and reducing and one that isn't.
Yeah,
So-
having those two
Point.
pools.
Barry's always so good at asking good questions.
So Jeff, here's a question I have for everybody that might be listening today. So we've got all these rules that are coming out. So what if you don't comply? Who's going to be the structural engineer reserve study cop for the state? How long is it going to take for them to knock on your door and say, you guys didn't comply? Here's the impact for not complying.
Well, it's going to be the Division of Condominium as to the structural integrity reserve study.
And
Not
that's
so
why,
sure,
I'm
Go ahead.
sorry, and that's one of the requirements, right? The filing by January 1st with the DPPR. They're doing that on purpose. They're trying to make sure they have a complete list
Right.
of who needs to be required to comply, because they're going to be tasked to make sure that they are compliant.
Mhm. We don't have the same language regarding the Sears versus the milestone in terms of the breach of fiduciary duty, whereas it's a breach to not do the structural integrity reserve study. But I don't think it's a very hard stretch to make that same allegation, if you will. But because the legislation is not in Chapter 718 regarding the milestone, obviously the Division of Condominium is not going to have jurisdiction over that item. And it would probably have to come through a DBPR, Department of Business and Professional Regulation enforcement arm for failing to comply with relevant legislation.
All right, here, this is a good question. We've talked a lot about it, but this is a very short question. There'll be a short answer. Isabel from Hallandale is asking, can reserves still be waived by a vote of the membership?
Right now, yes.
Yeah, that's true. Yeah, good. I'll go for that as well.
Yeah, right now, and then and that stops as of
December 31st, 2024, as to the structural items that we read out in little item G list, which we've read several times, it is clear those items cannot be waived or reduced, or any other item that is considered by the engineer, has that deferred maintenance cost greater than $10,000 and affects one of those items that we discussed.
So all properties with a year end of December 31st, that will affect your 2025 budgets. You cannot waive reserves for your 25 budget then.
The best you could do, but what might be to delay the impact of the entirety of the structural integrity reserve study until the 2026 budget.
Okay. There's still a lot of questions about
Still not
two-story.
waiving or reducing for any of those items, though, that are in little g. So, for example, where was it? You wanted to say the roof, for example, right? That's part of the little g items. So you're not going to be able to waive or reduce that past December 31st, 2024, even if you're not doing this, including the Sears and the Sears numbers calculations aren't going into effect until 2026. You still can't waive or reduce the roof and waterproofing and exterior painting, right? So the only one you might be able to still waive or reduce would be pavement.
Okay. Mark saying his Fort Lauderdale building just filed its 40-year recertification. Will they have to do a milestone report?
Yep.
The answer is yes, Mark.
What if you do the report and then you get the notice from local government? And the requirement from local government says you have to do this because the local governments are all charged in the legislation with reaching out to, right, all of the associations subject to the milestones, and then they have to get it done within X number of days. Well, what if you already did it yesterday? Another glitch.
Yeah. So here, Elizabeth, that'll be the last question, and we'll ask each of you a question to wrap up. It's on to 4 o'clock or 5 o'clock now. So Elizabeth asking, they have 2 buildings out of 14, which are 3-story. Do we have requirements on only these 2 buildings? I guess the other buildings are less than 3 stories.
You would not have to, right? This is on a per building basis. So if you have buildings that aren't stuck inside the scope of the legislation, then those buildings you'll be okay with. But the other
Even if
ones,
it's all one association, if it's all one association, doesn't matter, right? It's still, those costs likely get shared across the entire association. You don't win the lottery because you happen to be in a 2-story versus a 3-story.
It depends how that association divvies things up and how the documents were created. So I don't want to go into, well, only that building pays for this, because sometimes you have multi-condos and all the expenses are shared, across the board.
Right.
It's going to depend on that structure of that association in terms of who's paying. But
Okay, so it just hit 5 o'clock, so people are probably getting ready to go to dinner and do other things. So last question, I will start with you, Jeff. What advice are you giving your clients around funding for the new reserve laws?
what advice am I giving to clients to fund? Really, the advice is just to get ready and to prepare the membership for the impact of Senate Bill 4D.
Okay, Roxana, same question for you. What advice, because you're the ones that you're actually giving the advice and showing people how much it's going to cost because you're working on so many different budgets. So what advice are you giving our clients around funding for new reserve laws?
One, increase your reserve contributions. Don't just take the number from your calculation. And two, increase professional fees. Not only the fact that you have to build in some fee for that structural integrity reserve study, which we're getting quotes, and it's not cheap. It is going to cost more than your regular reserve study because it's a licensed engineer. And as Jeffrey pointed out earlier, there's only so many licensed engineers in the state of Florida. So the demand's going to be high. So the rates are going to be high. And also for legal fees. Throughout the segment, Jeffrey, you pointed out, you need to go to your individual attorney as well.
I think we're the least, I think we're going to be a very small cog on the wheel comparatively, compared to the cost of the engineer and the cost of the reserves. I'm not thinking the attorney on these little questions that come up from clients are going to break the bank.
True, but it's going to be more. Some associations have a culture of never calling their attorney, right?
Yep.
Others call all the time. But regardless, we know attorneys bill by hour.
Yeah. Wait till Tim gets my bill for today.
I wish I was on that pay schedule by hour. And so you need to increase $5,000, maybe 5 to 10,000. Hey, it's still money that has to be there.
Gosh, that's such a hard question to answer. But you heard the questions coming from the membership today, and membership, our listening audience, and I don't think that the questions are going to be a whole lot different than these questions. So what are we really looking at? An hour of time at most to get to most of these answers. It's different when you're doing more hand-holding with a client and reviewing reserve studies and pointing things out, and that's a whole nother use of the legal team. But if it's just for generic questions and things like that, I think you're looking at 0.4s to 1 hour of time to get to the end game. Only time will tell, though.
Yeah.
Okay.
And if I may add,
it's like a recovering effort for attorneys and engineers more than it is for attorneys, and more work for managers as well, and more expenses for the owners. Yeah, what was that?
I just wanted to add a recommendation and something that we're really taking into account and being ready to be able to do the matrices for all of our associations is be careful with your net cash position. So your available cash, make sure that your association's financial condition, you don't lose sight of it because of what we're saying, which is the fees, your assessments are going up. Collections is something else that we're training, we're reinforcing. I entered into the industry in 2008. It's not going to be like that. It's not going to be like those days, but there are inevitably some owners currently living at your associations that may not be able to afford to live there. So collections also is going to be in the forefront and definitely something that we're looking at collectively across all of our associations. So.
And the other part, the reality is costs are going up for wages as a result of the pandemic. So we're seeing a spike across the board. Roxana shared this with us in our partner meeting yesterday, just the increases for payroll for the different counties. And there is an increase that we're seeing because you want to keep your good people. It's harder to find good people today. Not as many people are in the workplace as there was pre-pandemic. So that's another impact. So insurance, reserves, and cost of people is all driving budgets up. And we're seeing close to double digits across the board this year.
Yeah.
So, all right, thank you, everyone. I know we're starting to lose some people. So we had a great audience today. We had a very spirited conversation. Not only was, I think it was great information shared, but it's a little bit fun. So Roxana and Jeff, thanks for making this fun, at least for
Thank
me. I
you.
hope our audience had a little bit of fun. We got to talk about Sears and Roebuck and country and western songs. So not all bad.
Thanks for
I
having me.
do want to sincerely thank Jeff Rembaum, from a firm member from Kaye Bender Rembaum. He is well-known, and thank you for your time. And Roxana Dorigo, Executive Director and Partner with KW. And also thanks to all the listeners who chimed in today. You will get a recorded version of this tomorrow at some point. Today's session is recorded. If you kill that email, you can always go to the KWPMC.com website and our YouTube channel, which is KWPM TV. We look forward to having you join us again at our next Best Practices for Community Associations webinar, the third Wednesday of every month. You'll get a note from me. So thank you all.
Thank you.
Thanks very much. Enjoy your Thanksgiving, everyone. That will be next week. So enjoy your Thanksgiving. Have a great rest of this week, and be safe and be kind to your neighbors. Thank you.
Thank you. Bye.
Bye.
Good night.